Good afternoon everyone. So in this session we will do industrial relations PYQs. Okay. So in this PYQs we will cover all the previous year questions with respect to EPFO 2017, 2020 as well as APFC examination questions with respect to industrial relations. We will cover each and everywhere. Okay. So let's start with our first question. So the first question talks about the basic terminologies and their definitions. Okay, usually what happens, where various codes are there, such as code on industrial relations, code on social security, code on wages as well as code on occupational safety. Within those codes, the government actually defines each and every term. Okay, so you can find similar definition when I'll show you the solution. But first of all, do the question. So first question is about what do we mean by closure, workmen, strike and lockout. These are the options. Try to do them. Okay, pause the video, try to do this. So usually strike is associated by employees. Okay, so it means a cessation of work by employees. Similarly, lockouts are the provisions that management uses in order to strengthen their position while collective bargaining. Okay, so temporary closing down of workplace by management is the lockout. So D3 and C4. And let's see the definition of closure also. Permanent closing, workmen, any person employed in any industry, skilled, unskilled, manual work. So A will be the right option. Okay. So let's move on to the solution part. So this is the solution. And these definitions I have taken out from the Industrial Relations Code 2020. Okay. So strikes, we mean cessation of work by a body of person employed in any industry. So that means cessation of work done by employees. Okay. Whereas worker is defined as a person working in any industry to do any manual, unskilled, skilled, technical, operational, clerical and supervisory work. But don't get confused by workers definition and employees definition. Employees definition although includes whatever is there in workers definition, but also includes administrative work and management work. Okay. Whereas closure means permanent closing down of a facility and lockout is temporary closing out of the workplace by the management. So I hope you understood these definitions. Now we will move on to the next question, which is about the definition of adolescent as per the Factories Act. So in 2020, EPFO asked who is an adolescent as per the Factories Act 1948, and this act have been subsumed under Code of Operational Safety, Health and Working Conditions. Okay, so the options given are who has completed 15 years of age but is less than 18 years, who is less than 18 years, 14, 18 and 16, 18. So pause the video, try to do this question, then I'll try to give the solution to you. So actually the answer is the person who has completed 15 years of age but is less than 18 years. So this is as per the Factories Act 1948. It's a person who has completed 15th year of age. So that means a person belonging to this age group is adolescent. And a person that crossed 18 years that crossed 18 years, more than 18 years is known as adult. Okay. So these are the definitions given under the Factories Act 1948. So the next question is about what is a controlled industry. So usually when we talk about controlled industry, it is under control of state. Okay. So take this as a cue and try to answer this question. Any industry, the control of which by the union has been declared by Central Act, by the state has been declared by State Act, by the municipal bodies or the state declared by Central Act. Try to do this question. I will try to give you the hint that similar thing is mentioned under list 1 of 7th schedule. If you know that list 1 is related to which government, then you will be able to do this question very easily. So the answer is actually the first one, that any industry, the control of which is by the union government, okay, and the control of which is given to the union government by any central act. Okay, so the A will be the right answer. So let's see the solution part also. So this controlled industry, the definition portion of it is mentioned in Industrial Relations Code as well as Code on Occupational Safety and Working Conditions. Occupational safety, health and working conditions. Okay. In both these codes, the definition of controlled industry has been given, and see what the controlled industry definition is there. That any industry, the control of which by the union has been declared by any central act. Okay, so this is mentioned under both these labor codes. Let's move on to the next question, which is about what is the minimum number of members required for the registration of trade union. As you all know, as per the Trade Unions Act and also as per the Code on Industrial Relations, trade union in our country has to be registered first in order to properly function within the organization. So in order to function, how many minimum number of members are required for the registration of a trade union? The options are 2, 3, 7, 10. Tell me what's the correct answer. So the right answer is 7 members. Okay. Now we will see what does the law actually said. So this similar thing, criteria for registration, was mentioned in Trade Unions Act 1926 also. So I have tried to provide the latest provisions that are right now applicable with respect to the same thing. So here also, any 7 or more members of a trade union may, by subscribing their names, can register themselves, okay, for the registration of trade union. Okay. There is also another provision with respect to trade union registration, that 10% of the members of trade union or 100 members, whichever is less, they must be employed in the organization where the trade union is getting registered. So suppose there is 1000 trade union members, okay, or you can say 10,000 trade union members, okay. So a trade union of 10,000 members is registered. So for that trade union to continue functioning, either 1000 members, which is 10%, or 100 members, which is whichever is less. So obviously 100 members of the trade union must be employed in the company upon which they are actually working, okay. So this is another rule with respect to registration of trade union that can come in the EPFO examination. Next is about the definition of trade dispute under Trade Union Act 1926. So trade dispute right now in the Industrial Relations Code is now termed as industrial dispute. Okay, so try to solve this question, that any dispute of any person connected with employment, non-employment, conditions of labor. What is the correct option? 1 only, 2 and 3 only, 1, 2 and 3, and 1 and 3 only. Try to give the answer. So actually the answer is C. That means all of it is correct. So any dispute of any person connected with employment, non-employment and condition of labor. There is also one more provision. We will see what is it under the law. So trade dispute or industrial dispute, the definition is provided under Industrial Relations Code. Okay, so it actually talks about industrial dispute means any dispute or any difference between employer and employees, employer and employers, employers and employers, employers and employees, and even employees and employees. Okay, so this act actually covers every type of dispute that can arise in an industrial setting, which is connected with employment, non-employment, terms of employment, and also conditions of labor. So these 4 conditions are there that has been covered under the definition of industrial disputes. And this provision, which was not present under Trade Disputes Trade Unions Act 1926, so it was not there. So this has been added under the Industrial Relations Code. Okay, so let's see what's this definition also include. So it talks about that it includes any dispute or difference between an individual worker or employer. Okay, so it actually talks about specific dispute that arises out of discharge, dismissal, retrenchment or termination of such worker. Okay, so it's a specific dispute between the worker and the employer with respect to these conditions: discharge, dismissal, retrenchment or termination. Okay, so next question is, what is the maximum amount of gratuity payable to the employees under the Payment of Gratuity Act 1972? Try to do this question. The options are 5 lakhs, 10 lakhs, 15 and 20. And there is a catch with respect to this, and we will see what does the catch is. So the answer, although initially it was 10 lakhs, after amendment it has been increased to 20 lakhs. Okay, so let's see the solution portion of it. Gratuity limit initially, as per the Payment of Gratuity Act, was mentioned 10 lakh maximum gratuity. Okay. However, recently the amendment has been done and the amount has been increased to 20 lakhs. Okay. So this is actually the maximum gratuity right now. And what are the provisions with respect to gratuity under Social Security Code? We will see that also. So, gratuity shall be payable to an employee when that employee has rendered continuous service within that organization at least 5 years. So, when an employee has been giving his services within a company for at least 5 years, then only he or she will be eligible for gratuity. Okay. And that gratuity will be given to him or her on his superannuation, on his retirement or resignation, on his death or disablement due to accident or disease, on termination of his contract period under fixed term employment, on happening of any such event notified by the central government. And this period of 5 years have been reduced for specific people such as working journalists as well as other newspaper employees. Okay. And it says that period is reduced to 3 years for these people. Okay. So this is mentioned over here. This is as per the Code on Social Security. Now let's go to the next question, which is very relevant for all the working people. They must be very interested in knowing these things. So what is the maximum number of hours in a week that an adult worker, which is more than 18 years, okay, is allowed to work for? So the options are 35 hours, we wish, 40 hours, we wish, 45 hours, we wish, 48 hours, we wish. Let's see. So tell me the right answer. Okay, then we'll see the what exactly is in the provisions of the law. So the answer with respect to this question is 48 hours. And let's see what does the law say. So this provision, that is hours of work and annual leave with wages, is mentioned under the Occupational Safety, Health and Working Conditions Code. Okay. So under this code, the law says that no worker shall be allowed or required to work in any establishment or class of establishment for more than 8 hours in a day. So for one day, maximum a worker will have to work for 8 hours. And what is the next provision? No worker shall be allowed to work in an establishment for more than 6 days in any 1 week. So 8 into 6, 48 hours within a week. Okay. So I hope this is clear. So let's move on to the next question, which is what is the maximum period in which the appropriate government shall review and revise the minimum rates of wages under Minimum Wages Act. So Minimum Wages Act have been subsumed under the Code on Wages. So just see, tell me what is the minimum period after which a government is liable to change or revise the minimum rates. So the options are 2 years, 3 years, 4 years, 5 years. The answer is 5 years. Okay. And let's see what does the law say. So both Code on Wages as well as Minimum Wages Act says that the appropriate government, so why appropriate? State as well as center both will determine the minimum rates. Okay. Shall review or revise minimum rates of wages ordinarily at an interval not exceeding 5 years. So at least after 5 years, 5 years is the maximum limit. They can revise within 5 years, but after 5 years they have to revise or review the minimum rates. Okay, so this is the law. And some other provisions are also there, that no employer shall pay to any employee wages less than the minimum rate of wages, which is self-explanatory. Okay, and for the purpose of subsection 1, which is the minimum rate, the appropriate government shall fix minimum wages for time work, for piece work. So time work is self-explanatory, that is per day wage, per month wage, okay, or per week wage. But for piece work, suppose per unit of work, or you can say production, so wages are determined on the basis of this metric. So suppose if you are writing any content, if you are writing or providing any IT services for a particular company, okay, so per script or per video you will get video, the amount. Okay, so this is actually minimum wage per piece work. Let's move on to the next question, which talks about under Sukanya Samriddhi Yojana, what is the maximum amount that can be deposited during a financial year. So within a singular financial year, how much is the maximum amount that can be deposited? So the answer is 1.5 lakhs. So let's see the details about Sukanya Samriddhi Yojana. So this Yojana was launched exclusive for a girl child. Okay, launched by Prime Minister on 22nd January 2015 as a part of Beti Bachao Beti Padhao campaign. Okay, and this can be opened in the name of a girl at any time from her birth till she attained the age of 10 years. So 10 years, post 10 years, you cannot open a Sukanya Samriddhi account, and minimum deposit is 250 rupees and the maximum within the financial year is 1.5 lakhs. Okay. Next is, what is the minimum and maximum age which a subscriber can join Atal Pension Yojana? Atal Pension Yojana was actually very important at that particular point of time, because the numerous questions with respect to this scheme came in EPFO 17 and even APFC 2016. Okay, so tell me what's the correct answer. 21 years, 58 years, 1840, 1850, 2160. So the right answer is 18 and 40 years respectively. So let's see the solution portion of it. So this is an initiative of the government launched on May 9, 2015. The benefits subscribers would receive: guaranteed minimum monthly pension that will range from 1000 to 5000 rupees. Okay. And the eligibility is 18 to 40 years, and who are not income taxpayers. Okay, and because this actually caters to unorganized workers, unorganized people from unorganized sector, primarily focuses on those people. And with respect to central government contribution, central government is actually providing guarantee with respect to the minimum pension, and if that contribution is lower than the estimated return, then that will be provided by the central government. Any advocacy will be provided by the central government. So this is the only contribution by the central government under Atal Pension Yojana. Okay, and as you can see, monthly pension is available to subscriber after him to his spouse, and after both their deaths it will be returned to the nominee. So I hope this is clear. Let's do another question. It is about works committee, safety committee, canteen management committee are the examples of workers' participation in management, workers' education schemes, worker cooperatives, worker suggestion schemes. So the correct answer is workers' management, participation in management. So the works committee, these committees are actually established under Industrial Relations Code. These include equal representation from employees as well as employers. Okay, and they discuss amongst each other whatever their issues are. Okay, so this is what the works committee is related to, and similar works committee, if they are specifically created for safety and specifically for canteen, and these are differently known as safety and canteen management committee. So as you can see, this is the law under Industrial Relations Code. It says that any industrial establishment in which 100 or more people are employed, then appropriate government may by general or special order ask the employer to constitute a works committee. Okay, and this work committee, what it will do, it shall be the duty of works committee to promote measures for securing and preserving amity, which is harmonious relationship between the employer and workers. Okay, so now you know the conditions after which works committee will be established and what is the primarily duty of works committee. Okay, and the membership is provided that the number of representative of workers in such committee shall not be less than the number of representative of the employer. So that means 50-50, or at least the numbers of representatives of employer and the employee should be the same. Let's move on to the next question. Next is about the Philadelphia Declaration. Okay, so it actually asks about which one of the following is not the part of aims and purposes of the Philadelphia Declaration. Okay, so labor is not a commodity, which is a positive aspect, so this should be correct. Freedom of expression and association are essential to sustain progress. Again, a positive aspect, should not be incorrect. Poverty anywhere constitute danger to prosperity everywhere. So this is also a very good statement. It should not, it should be a correct thing. The war against want requires to be carried on with unrelenting vigor within each nation and is solely the responsibility of the government. So this is actually wrong, and that means this should be the correct answer for 72. Why solely the responsibility of government? Employees, employers, citizens, international organizations, everyone has the duty to fight against want. Okay, now let's see what was the exact text of Philadelphia Declaration. So this was the ILO Declaration of Philadelphia, which actually concerns the aim and purposes of International Labour Organization. So learn this. So this was the 26th session of ILO in Philadelphia, okay, and it occurred on 10th May 1944. Okay, and see, the questions are very basic, even copied directly from the Philadelphia Declaration itself. So labor is not a commodity, freedom of expression, poverty anywhere, the war against want. It says by continuous and concerted international effort in which representative of workers, employers enjoying equal status with those of governments join with them in free and democratic decision with respect to labor issues. So in the last document, in the last statement, it says that various stakeholders are actually working in a concerted manner in order to deal with the labor issues. Okay, now let's move on to the next question, which is about which of the following is an exception from the 5 functional types of unionism led by Robert Hoxie. So Professor Robert Hoxie talked about 5 functional types of unionism. So tell me which one is not the one mentioned by Professor. So the first option is business unionism, which was there. Predatory unionism, which was also there. Revolutionary unionism was also there. Evolutionary unionism was not given by Professor Robert Hoxie. So the answer for 73 should be D. Okay. Now let's see what theories or what functional types were given by Robert Franklin Hoxie. And this approach with respect to unionism came to be known as social psychological approach, in which, and his book was Trade Unionism, okay, and his greatest contribution to the theory of trade unionism was to establish the functional type of labor organization. So the first one is business unionism, friendly or uplift unionism, revolutionary, predatory, and dependent unionism. Okay, so these 5 are the functional types that the Robert Franklin Hoxie talked about. Next is, which one of the following is the process in which representatives of workmen, that means employee representation and employer representation involved in an industrial dispute, are brought together before a third person. Okay, so third person is also there, or a group of persons who facilitates through mediation. Okay, mediation is going on to reach a mutually satisfactory agreement. And this is also another key term, mutually satisfactory agreement. So let's see what are the options: arbitration, adjudication, conciliation, and collective negotiation. So collective negotiation right now is incorrect, because this is a process before industrial dispute where both these employers and employees actually chart out terms of employment. Okay, so this is wrong. Arbitration is also wrong, because, and similarly adjudication are also wrong, because they in the end provide a judgment or settlement that is binding on both parties. And since it is a judgment, so it is not a mutually satisfactory thing. And these are the adjudication, that means it is a formal thing that actually adjudicates on the industrial dispute, whereas conciliation, it's actually a form of mediation. Okay, so third option becomes correct. Okay, I hope this is understandable for you. So these are the definitions. It is a form of mediation under which the services of a neutral person are used as a means of helping the disputing. Okay. In arbitration, getting the dispute settled through an independent person chooses by both. Adjudication, it is actually settling disputes through intervention by the third party appointed by the government, and these parties include labor courts or industrial tribunals. Okay. Let's move on to the next question. This is about questions relating to application or interpretation of standing order certified under Industrial Employment Standing Orders Act may be referred to. So this is talking about the jurisdiction of the bodies mentioned in the option. So what is the jurisdiction of Industrial Tribunal? Labor Court, Commissioner and Employment Court. And these jurisdictions are mentioned under Industrial Disputes Act and also Industrial Relations Code. So first of all, give me the answer, then I'll tell you what actually is the provision mentioned under the law. Okay. So answer of this question is Labor Court. Okay. And what are the jurisdiction of Labor Court mentioned under Industrial Relations Code? Let's see those. So under second schedule of Industrial Relations Code, jurisdiction of labor courts, and see the first thing. The first thing has been asked in the examination, that propriety or legality of an order passed by an employer under the standing orders. Okay. Or the application and interpretation of standing orders. So while learning or while preparing for industrial relations, we have to just focus on the topmost portion with respect to any important thing. Okay. Let's see other things also. The discharge or dismissal of workmen, including reinstatement or grant of relief to him, withdrawal of any customary concession, illegality or otherwise of a strike or lockout, all matters other than those specified in the third schedule. So what is third schedule? So third schedule actually talks about the jurisdiction of industrial tribunals. Okay. So see the content with respect to industrial tribunals jurisdiction. So any issue or dispute with respect to these matters will be referred to industrial tribunals. So what are these issues? Wages, compensatory allowances, hours, leaves, bonus, shift working, classification of grades, discipline, rationalization, retrenchment, and any other matter that may be prescribed. So I hope this is very helpful for you. Second schedule, third schedule, industrial tribunals, labor court. Okay. And this is all mentioned under Industrial Relations Code. Let's move on to the next question, which is about a union whose membership may cover workers employed in many industries. Employment and crafts is known as. So tell me the option. So tell me the answer. The options are industrial union, general union, craft union, region cum industry level union. So even if you study the question which actually talking about crafts, so you can see this is the correct answer. Craft union. Okay, so these are the specific unions that actually caters to specific industry. Okay, industrial union specific to industry. So such as automobile union or something like that. General union transcending. General union, no differentiation. It's like no differentiation with respect to industry. So all just like AITUC, All India Trade Union Congress, okay, that transcends every industry, every type of workers, which on a pan-India level favors workers in general, okay. So industrial union, they are industry specific, such as Bharatiya Mazdoor Sangh, Bharatiya Kisan Union, catering to different industries, okay. So these are the definitions. If you want to look at it, you can pause the video. It's just the same that I have explained to you, okay. Next is, which of the following perspectives of industrial relations is based on the assumption that both the parties strive and have opportunity to exercise economic wages as well as political power. So this perspective actually talks about that there is an independence or freedom that both parties have. Both parties meaning management as well as workers, okay. So these both parties have freedom to pursue economic as well as political power. So unitary is wrong because it is a paternalistic approach led by the employer. Radical is also wrong because here workers think they have the right to the power. Trusteeship is also wrong because it is also similar to the paternalistic. So pluralistic perspective is the right answer, okay. So in pluralistic approach, it suggests there are more than one source of power in the relationship between workers and business leaders. Unions are the central component to that. Okay, so two centers of power within the organization. Both can actually focus on securing economic as well as political power. Next question is about provision of workers' participation in management of industries is provided under which article? So this is very important. You prepared DPSP, fundamental rights with respect to industrial relations, okay, or anyways you have to prepare because this is under your syllabus of polity, okay. So the answer for this is Article 43A of the Constitution of India. So this was actually added by 42nd Constitutional Amendment Act 1976, workers' participation in management, okay. Let's go to the next thing, which is trade union security measure, which is not. So the options are closed shop, agency shop, open shop, union shop. So right now the answer is open shop system. And let's see what do we mean by these things. So under closed shop security measure, the recruitment of workers is solely given to trade unions, okay. So every responsibility with respect to recruitment of workers and their joining is solely given to the trade unions, and it is their sole responsibility. That's why it is known as closed shop. No involvement of the management, okay, and even no freedom given to the workers with respect to joining or non-joining of trade unions. Next is union shop. That it says that there is an agreement that all newly recruited workers must join the union within a fixed period after employment. So there is a fixed period under which the employees have to join the trade unions. Next is about agency shop, where although with respect to joining trade unions there is no conditionalities, however, since trade unions actually perform or represent these workers in front of management and actually secure economic and various other benefits for these workers, so they will charge a agency fee. So all those people who are actually not joining the trade unions will have to pay agency fee, and such type of arrangement is known as agency shop. Okay, so you can see in terms of trade agreement between management and union, a non-union member has to pay the union a sum equal to a member's subscription in order to continue employment with the employer. Next is about open shop, where there are no conditionalities with respect to anything. So it's like a conditionalities. So that means trade union has no role with respect to that, any aspect of employee. Okay. So that's why it is not considered as a trade union security measure, because there is no involvement of trade union in open shop. Now let's move on to the next question, which is about which one of the following is statutory machinery functioning at the central level. Statutory machinery, that means through a statute, that body established through a statute or a law. Okay. So which of these bodies do you think are established by a law? The options are Evaluation Central Implementation and Evaluation Committee, Central Board for Workers' Education, Standing Labour Committee, and Employee State Insurance Corporation. So I hope you know the answer, which is actually D, Employee State Insurance Corporation, which was established through ESIC Act 1948. Okay. Let's move on to the next question, which is about which of the following explains the citizen concept of labor. So under such questions, what you need to do is just look for the option that actually makes common sense, okay, and is not actually wrong in a common sensical way. So let's see. Let's read these options. Labor is largely regarded by the employers as operating organizations in industry. So it's like objectification of workers. So they are actually being used as an operating organizations. Okay. So this should be incorrect. Labor is affected by the law of demand and supply. Similarly, same thing. It's like an object which is either in high supply or low supply. Labor has a right to be consulted in regard to terms and conditions under which they are supposed to work. So this statement actually talks about rights of worker, it talks about dignity of worker, because it is actually consulting the worker before charting out the terms and conditions of its employment. Okay. So this should be correct, and let's see the last option. Labor is a cog in the machine, so just a part of the whole system. Another thing which is actually reducing the dignity of a labor. So C should be the correct answer. Okay. So with that mindset, go in the examination, think about the options in terms of common sense. Obviously, in case of theoretical aspect, we can't do much thing, but having an approach based on common sense really helps in various examination organized by UPSC. So next thing is about who among the following can be appointed as the chairman of the Central Advisory Board constituted by central government under Minimum Wages Act. So the options are independent members, representatives, employers representatives, employees representative, functionary of the central government nominated by government. So these two options can be eliminated, because if we choose either employees representative, then these people will feel injustice, if and vice versa. So we can cross these questions. So under such circumstances, we will try to, if we don't know the answer, we should go for independent members. And although in the hindsight these things look easy, but in the exam, if we don't know the answer, we should approach these questions in such a manner only. Okay, even if you did this wrong, but because you are actually trying to do many questions, so various net result will be positive. That's what I'm trying to convey here. So as you can see, this is mentioned under code on wages. Code on wages. Okay, so central government shall constitute the central advisory board, which shall consist of a person representing employers, representing employees, independent persons, 5 representatives of state government. Okay, and 1/3 members shall be women. And what about the chairperson? And a member specified in clause C. So what is clause C? Independent persons shall be the central government as the chairperson of the board. Okay, and the appointment of the chairperson is being done by the central government. Let's move on to the next question, that which of the following comes under state list under 7th schedule of the Constitution of India. So 7th schedule actually talks about various list, state list, central list and concurrent list, where both parties or both governments can actually make law. Okay, so the first thing is relief of the disabled and unemployable, regulation of labor safety in mines, regulation and control of manufacture, supply and distribution of salt, social security and social insurance. Okay, so think about what option can be correct. So actually the answer is relief of the disabled and unemployable. So let's see the answer. So these are the entry lists that I have prepared, that things which are related to labor. So as you can see from the entry 9 of state list, relief of the disabled and unemployable, and these are the various articles mentioned under union list. Entry 52 talks about controlled industry, which we did earlier. Okay, regulation and development of oil fields, mineral resources, petroleum and other liquids, regulation of mines and mineral development, and lastly regulation of labor and safety in mines and oil fields. Whereas in concurrent list, trade unions, industrial labor disputes are there, social security and social insurance is there. Okay, welfare of labor including conditions of work are there. So before going to examination, just have a look at these lists, and this is a very short 1-page list. Then you'll be much more sorted with respect to any constitutional question that can come in the examination. Okay, let's move on to the next question, which actually talks about which theory assumes that man is selfish and self-centered and always tries to achieve his own ends even at the cost of others. So just use common sense that if a man is like this, then how do we control such kind of a man, and then try to do this. Okay, when a person is like that, then usually such person create ruckus or do illegal work, and we don't want such people to continue with their illegal activities, and we want to create a standard policy or law that should be adhered by those people, and that can only be done through policing. So this is the correct answer. So police theory is based on the contention that a minimum standard of welfare is necessary for laborers, and since this theory assumes that man is selfish and self-centered, this theory thinks that employer, in order to increase their profits, will not give basic welfare for the workers until or unless being told by the police or the government. Okay, so this is what the theory is all about. Now let's move on to the next question, which is about Dr. Aykroyd's formula is associated with the determination of fair wage, minimum wage, living wage, real wage. So tell me the answer. And this formula has been used to determine wages under 7th Pay Commission. So now tell me what should be the answer. So the answer is minimum wage. Okay. Dr. Aykroyd was a famous nutritionist. Okay. Now read this question. Everyone, and such questions are like that we feel that we may not be able to do this, but if we have to do such type of question, what should be our best possible option that we can take? Okay. Now read about this, that everyone as a member of society has the right to social security and is entitled to realization through national efforts and international cooperation, and in accordance with the organization and resources of each state of economic, social and cultural rights indispensable for his dignity and free development of his personality. Okay. So dignity, rights, these things primarily we can say is associated with human rights. Okay. So the answer is Universal Declaration of Human Rights, and this is mentioned under Article 22 of Universal Declaration of Human Rights. There are other things also mentioned, so you can have a look at it. This I have already told you. In Article 20 of Universal Declaration of Human Rights, everyone has the right to freedom of peaceful assembly and association related to the trade unionism. Everyone has the right to work, to free choice of employment, to just and favorable conditions of work without discrimination. Okay, favorable remuneration, right to form and join trade unions. And Article 24 talks about everyone has the right to rest and leisure, including reasonable limitation of working hours. Okay, so these things are mentioned under Universal Declaration of Human Rights. Let's move on to the next question, that for the first time in India, medical benefit as a non-cash benefit was provided under. So such benefits are associated with Social Security. Okay. So you can eliminate these things. Now under Maternity Benefit Act and Employee State Insurance Act, this provides benefit of specific, it's actually specific for women. Okay. And Employee State Insurance Act is actually broad in nature. So the right answer is Employee State Insurance Act. Okay. Next thing is about which one of the following set of contingencies identified by William Beveridge in his comprehensive social security schemes. So this is a very theoretical aspect. Contingencies importance is under the concept of social security, which talks about various contingencies or providential mishaps upon which a human has no control. Okay, so these are the options. The correct option is A. And let's see the answer. Want, disease, ignorance, squalor and idleness. So this is the guy. Government, people and all the stakeholders fighting want, ignorance, disease, squalor and idleness. And what are the various policies with respect to each and everything? So it talks about adequate income for all, access to health care, access to educational opportunity, adequate housing, gainful employment. Okay, so these are the 5 contingencies mentioned by William Beveridge. See again, Atal Pension Yojana came back. Which of the following is not correct? Guaranteed minimum pension between 1,500 and 1,000, correct. Benefit of minimum pension would be guaranteed by the central government of India, correct. Government of India contributes 50% of the subscribers contribution or 1,000 rupees per annum, whichever is lower. It was initially there, okay, but and right next is it is applicable to all citizens of India aged above 40 years. So as we all know, the eligibility criteria was 18 to 40 years. So above 40 makes this statement wrong, hence the correct option. Okay. You can again go through this document. Which one of the following amount of annual premium under Pradhan Mantri Suraksha Bima Yojana? So this is Bima Yojana for providing accidental cover. So this is a dynamic question. At that particular point of time, the annual premium was 12 rupees only. So at that time, D was the correct option. But this now has been changed to rupees 20. So right now, annual premium is rupees 20. So remember that portion only. Okay, with respect to Suraksha Bima Yojana. As you can see, it is a 1-year accidental insurance cover. 18 to 70 years is the eligibility criteria, and this is the cover. 2 lakhs is for death cum disability, and in case of partial disability, the amount is 1 lakh. And 20 per annum is the premium that has been changed. Okay. Next question is about Pradhan Mantri Jeevan Jyoti Bima Yojana. Okay, so tell me which of the above statements are correct. So have a look at it, try to do this question, then we'll try to solve this. So first of all, it is saying that it is applicable to all adults above age group of 18 years, no maximum age. So take this with a pinch of salt. The premium is deducted from the account holder's bank account through auto debit facility, correct. Life insurance worth is decided by the account holder and he has to pay the annual premium accordingly. This is wrong because worth is already fixed and similarly the premium is already fixed under this scheme. So 3 becomes wrong, 1 and 3 is wrong. Okay. 4th statement is already correct and 2nd is correct. So answer should be C only. Life insurance amount is given to the family after the death of the subscriber. Self-explanatory thing. Okay. So this is Jeevan Jyoti Bima Yojana, 1-year life insurance term. Okay. 18 to 50 years eligibility, and even for people joining after 50 years age, life insurance have covered up to age of 55 years. Okay. So life cover of 2 lakh in case of death due to any reason, and this premium has also been increased to rupees 436 per annum. Okay. So remember this. Next is Employee State Insurance Act covers factors like, tell me what are the benefits under Employees State Insurance Act 1948. So let's see. Factories and establishments with 10 or more workers. So these things are applicable to this conditionality, provision of comprehensive medical care to employees and their families. It should be correct. Provision of cash benefits during sickness and maternity. It should be correct because these things are contingency under that warrants social security, monthly payment in case of death or disablement. So all options are correct. So let's just see this conditionality also, what is right now in the Code on Social Security. Although ESIC Act mentioned the same, but even Code on Social Security also talks about the same. That factory means any premise include precincts where 10 or more persons are employed. Okay, and these are the benefits for insured persons as well as their dependents. Okay, and this is under sickness, for maternity also, miscarriage or sickness out of pregnancy, suffering from disablement also. So just have a look at these things that are mentioned under the law. Now let's move on to the next question, which is theoretical in nature. So if you know the definition of Social Security, it says that benefits provided by, right now in our case, state against any contingencies or providential mishap. Providential mishappening upon which people don't have any control. So against these contingencies, if there are benefits provided by the state, these are known as Social Security. So let's see all these things and check whether they are contingencies or not. So on these things, whether a person has control or not. So for sickness and disability, don't have any control. For unemployment, also don't have any control, because because of the various business conditions, tech companies are actually laying off. So no issue of workers are there. Crop failure also, weather dependent, loss of marital partner, no control. Okay, so option should be D. Okay, so if you focus on the theoretical aspect, then the confidence while answering these questions will be higher. Okay, let's go to the next question, which is again Pradhan Mantri Suraksha Bima Yojana, applicable for all bank account holders up to age 60 years. It is a life insurance cover, which is very wrong, because it is a accident insurance cover. Okay, insurance covers death and permanent disability due to accident. So first of all, 2 is incorrect, and since 3 is correct, so option B is the right answer. Okay, now let's move on to the next question. This I have already explained to you. Next question is about Atal Pension Yojana. Again the same thing. We all know 18 to 40 years is the beneficiary eligibility, correct? Beneficiary will receive pension only after he attains 60 years. Very correct. After death of beneficiary, his spouse continues to receive pension. No nominee of the beneficiary is permitted. This is very wrong, because there is the provision that in case if the subscriber as well as spouse dies, then nominee will be getting the benefit under Atal Pension Yojana. Okay, so answer should be 1, 2 and 3 only. Here it is mentioned. Okay, let's move on to the next question, which are the following instruments of providing social security in India. Select the correct answer. So think of these terms in terms of providing benefits. What all things are actually providing benefits to the people. So accordingly, we'll be able to get through our answer. So employees provident fund, obviously it's providing benefits. LIC providing insurance cover, yes. Pension scheme also. Postal provident fund. 2, 4, 5, 6. C should be the correct answer. And in the reverse case also, income tax is not providing any benefits. General sales tax is also not providing any benefits. These things are imposed, and it takes money from the people. Okay, so 1, 3 should be eliminated, and you'll again go back to the correct option. Next is about Maternity Benefit Act provides for how many week wages during maternity period. So although the answer was 12 weeks and this was as per the Maternity Wages Act, but right now amendment has been done, and as per Code on Social Security, the benefits under maternity has been given to 26 weeks. So this 12 weeks period has been amended to 26 weeks. So please do remember this newly appointed provision. Okay. So I have prepared a comparison document that initially under Maternity Benefits Act there was a provision of 12 weeks. However, this has been amended to 26 weeks under Code on Social Security. Okay. And there is also another condition that provided that if a woman has 2 or more surviving children, okay, then that benefit will be reduced to 12 weeks. So please make sure that you remember these critical aspects that has been amended, okay, and that is more relevant for your examination. Next is the famous Giri approach in industrial relations is related to or espouses the cause of. So this approach is related to Mr. V.V. Giri, who was the Labour Minister of India and who actually favors negotiation or sitting down discussion in order to resolve industrial disputes. So he favored that employer and employees must sit together and resolve disputes before going to other authorities and other organizations in order to settle those disputes. So obviously this phenomena is actually talking about compulsory collective bargaining, because all other things actually involves third person. Okay. So all the best to all of you from my side. Trust yourself, have a common sensical approach while doing the theoretical or the questions related to the theory. Okay, so you will be able to do much more questions, and just keep on revising the industrial relations theory. Okay, and also keep on revising the important acts or even the important codes. And with respect to, if you find that code on all the 4 codes are actually very much more for you to revise, then there is a document on the Labour Ministry website. Okay, it's like an e-book for labor codes, where important aspects with all related to all labor codes are there. Okay, so you can go, it's like a 30-page document, and 30 page I'm saying it's like having a larger font. Okay, so don't worry, and mostly there are pictures only, so just stick to the basic major things with respect to all the different codes, be it on wages, be it on industrial relations, be it on occupational safety, health and working conditions, or be it on social security. Just prepare, have a look at these 4 codes of wages or 4 codes of labor. Okay, then you will be at least much more sorted with respect to the acts and regulations part. Okay, prepare theory also, and trust yourself, you will do well. So thank you for joining.